I'm Bernie Musri. I'm a solicitor specialising in construction and general litigation, and with me today is Mr. Andrew Hack, who is a fairly esteemed colleague of mine and someone who's worked with me as a mentor for a number of years. He's a litigator who works primarily in insolvency, financial law, and a little bit of personal bankruptcy as well. All right. So everyone, welcome to Caselaw Club. All right. So today we have the matter of Cyprus Community of New South Wales Limited, a 2024 case of the New South Wales Supreme Court, number 1629. And this is actually quite an interesting little case. It deals with the appointment of administrators. Yeah. And it deals with a alleged wrongful appointment where they were appointed for perhaps other reasons other than it was necessary, that there was a likely incidence of the company trading insolvent in the immediate future.
Right. So it's a company, not the other type of organisation.
Well, it's a club. It's a limited company, but it doesn't say what it is. But it's governed by its members. Limited
by guarantee.
And possibly we might check back in and add that information in post if it's convenient. But it's governed by its club members and its voting, and it's fairly restricted in that operation, which is a little bit of a problem that they run into, and one of the reasons why insolvency was such a living problem. But let's start at the beginning, shall we?
Yeah.
So the case involved a claim by Cyprus Capital Limited and Dr. Costa, who was a director of Cyprus, and they were secured creditors of the club, and they already had an amount of debt. They've loaned money to the club, and the club was nearing insolvency, and it wasn't bringing in enough money. So the board of directors had sought to move the club into voluntary administration. And after that happened, Dr. Costa brought a claim alleging that they'd been appointed for the wrong reasons. He claimed that the voluntary administration had been entered into so that they didn't have to enter a general meeting of the club members, and he suggested that general meeting was likely to result in the directors being removed as members, or as directors, rather.
It's essentially a membership squabble.
Yeah, it's essentially a membership squabble.
Yeah.
But funnily enough...
things are like chess games.
Oh, yeah.
Everyone's moving pieces behind the scenes. And then everyone's got ulterior motives.
When it ends insolvency,
well,
well and truly everyone's turned on each other and no one wants to be a part of the thing.
Well,
Some of the directors alleged they didn't want to be directors, and they were bound to their positions by responsibility, et cetera, et cetera. So there's a bunch of different people claiming different things. Anyway, so this matter comes to court, and the court considers whether it was for an improper purpose. Now, one of the central components of this particular matter was the sale of property, because the club had an enormous amount of money in real property that it had access to.
Right.
But it couldn't sell that property without the permission of its club members, without a vote to do so.
Uh-huh.
It actually, I think, couldn't even make changes to its operation to allow additional income to come in without the vote of its members. And there had been an earlier case preventing the directors from selling property without, the permission of its members, without a vote of its members, which would then allow the property to be disposed of. That was a particular issue because without the sale of property, they were going to be trading insolvent, and they'd balance themselves on a pretty fine line of the action that they could take. So, it came into question. Dr. Costa complicated the matter by offering a loan if the directors stepped down. So hypothetically, if they had stepped down, he would provide a loan, kept the company in its solvent state, And, this complicated the matter. Well, why don't we jump to paragraph 8 of the judgment?
Dr. Costa's submission. I am concerned that the board of the club passed the resolution to appoint the administrators so that it would not need to call a meeting of the members to elect a new board or discuss the future direction of the club and how it should deal with its real property assets, and to provide full disclosure to the members about how the board had conducted the process for investigating the club's real property development options. Based on my understanding of the club's position at the time it appointed the administrators, I do not believe that the board of the club could have formed a view that the club was or would become insolvent. This is because, among other things, the club had significant cash reserves and over $40 million in real property equity.
So that part is quite important, because the judgment focused on the legal definition of insolvency, which is whether or not there is working capital to pay out the debts as and when they are due.
Yeah.
Which, having enormous, equity and cash in capital available doesn't mean that cash will be available. In the books. Owning that property doesn't mean that can be disposed of in time to pay out their current debts as they become due and payable. And the court considered whether there was a possibility that there was an alternative consideration. And in the grand scheme of things, they came to the conclusion that once the board had come to the conclusion that they were likely to become insolvent, that it was a real and present concern, then that was something that allowed them to appoint the administrators fairly.
Yep.
And the question was, it was a practical one. And because there were conditions that had to be met, either the board had to, step down and appoint new directors, or, come to a general meeting whereby they'd be able to obtain finance, because one of the things they were limited in was their ability to obtain further finance. Maybe it would happen, maybe it wouldn't happen. Dr. Costa was prepared to offer that loan, so the loan was there available, but
the director stepped down. That sounds super manipulative.
Yeah. Well,
that submission that he's making right there sounds very sensible, at least on its face. But when you're saying, and he offered $1 million loan to help with cash flow, which presumably there was some cash flow issue, if the director stepped down, super manipulative.
Yeah.
I don't think that's... Look, I saw this judgment, but I didn't read it, so... it would be interesting to see what Justice Black had to say about that.
We should go to some of his judgment.
Because I have to say, again, that submission again on its face sounds kind of reasonable, but the minute you're saying appointment of administrators for an improper purpose, my spidey senses are tingling a little bit.
Very aptly so.
I start off from a position of doubt, but there was one a little while ago. I think it was a decision of Justice Williams where she set aside an appointment of administrators, which was made for an improper purpose.
Yeah,
it was very critical of the administrator for conducting a whole lot of work, where that was a fraud allegation though.
Yeah,
one director. There were two directors. One director made the appointment, fraudulently signed the signature of the other director. The problem is the director whose signature was allegedly forged brought the action eventually. I think the administrator brought the action eventually at the insistence of that director. So the director that made the appointment, who supposedly forged the signature, gave no evidence. So the problem was that the evidence that the signature was a forgery was unchallenged. But anyway, so it definitely happens that they do get appointed for improper purposes.
Yeah, I think the court mentioned that was a fair claim. Well, let's read this.
Yeah.
Right. So this is discussing the claims made by Dr. Costa. They say, paragraph 9, the first of these propositions is consistent with the improper purpose case brought by the plaintiffs, it seems valid. Although I will find below that the case has not been established, the second proposition does not reflect the statutory test for the appointment of a voluntary administrator, which includes whether the club was likely to become insolvent at a future time. Legal test for it.
Mm-hmm.
I'll explain why the evidence establishes that, as the matters stand, the club is plainly likely to become insolvent by February 2025. That involves a investigation of some of the finances. I think is necessary to delve into that. It's sufficient to say that it was likely to so become. Where it does not have any member approval for sale of its property and cannot realise the property. So the key problem is that it needs member approval to do the thing. There's a condition attached to the thing, and if the condition isn't passed, notwithstanding that it appears that the condition might be passed,
gotcha.
If the condition, the fact that there's an existent condition, means that where it does not have member approval for the sale of its property, it cannot realise that property. And the plaintiff's suggestion that may change the likelihood of insolvency, that is, may change, was no more than speculation. There is no process presently in train to obtain such approval and no basis for the court to speculate as to whether or not that approval might be successfully sought and obtained in the near future, contrary to what has occurred in the recent past, which is, I might suggest, one of the most artful, to me it seems, summarizations of a fairly
complicated matter.
Yeah. And I think the key thing is that they've identified, Justice Black has identified, that it turns on whether there's a condition, and there's no way to speculate what that condition is going to be satisfied or not satisfied, or rather that any attempt to identify whether the condition is going to be satisfied or not satisfied is speculation.
The condition in the Constitution. Is that what we're talking about?
The condition in the Constitution
For member approval.
For member approval.
Yeah.
So because members are a fickle bunch with the chess games you mentioned going on.
Yeah.
Who knows what the ultimate outcome is likely to be?
Yeah.
And maybe you can say that all the chips are in a row for it to be approved.
Yeah.
Of course, they're going to say yes if it's insolvency or if it's a loan or just disposal of the property. Of course, they're going to say yes. But they still have to say yes.
Mm. Yeah, but you got to resort to members. Yeah, it gets super political at that point.
Yeah. The whether or not
they're not all going to be reasonable
is it's betting on the basis of a political outcome.
Yeah, because it's not as much a business as it is something else to the members.
Yeah. Oh, yeah. Yeah, it's a very personal thing that they're choosing to do.
Well, yeah, I just think it might be that, the show's over, but a lot of people don't want to believe that that's the case. Well, if they have just run out of money.
My read of it was sort of the opposite, because they have an amount of property which is valued something in the vicinity of 56. They said if they develop it, it might be $75 million worth of property. So it's like, okay, there is definitely a substantial amount of money which is available here.
Yeah.
And perhaps the administrators, when the entity moves into voluntary administration, are going to be able to recover it. Perhaps they will. But the question of whether or not it would be done without that step being taken is an open one.
Yeah.
And the legal definition of when the debts come due that's a strict test.
Well, yes, sort of. I mean, it's a cash flow test.
It's a cash flow
and
test.
It's an art form in itself, because it's usually proven by expert evidence from a liquidator. It's opinion evidence, usually. So I'll be interested to see what evidence the various parties put forward there. Presumably there were various liquidators giving evidence.
I don't recall exactly what evidence was submitted, I think that they do talk about a bit. Let's see if we can find it.
I suppose then it's a bit watered down in the sense that the directors just have to have that reasonable belief.
Yeah.
As opposed to, say, in a winding up where the court needs to find as a matter of fact whether the company is insolvent based on the cash flow test.
And that's something that they actually talked about. They talk about whether or not the directors at a particular meeting reached the conclusion that the company was likely to become insolvent.
Yeah.
The court accepts, quote unquote, that the evidence establishes that as matters stand, the club is plainly likely to become insolvent by February 2025. But it's conditional
on not having member approval for the sale of its property.
That's right. And there was actually an attempt to obtain further finance, which was blocked by an earlier decision. It said constitutionally the organisation requires member approval.
Yeah. Okay. I see the conundrum.
So Dr. Costa has provided evidence and Mr. Kelly has provided evidence. I believe Mr. Kelly may be one of the directors.
Kelly doesn't sound very Cypriot, though. No, he's one of the administrators.
Cypriot, what's that word mean?
Cyprus.
Oh,
from Cyprus.
Okay. That's a new one for me.
Cypriot Greek.
Yeah, so Mr. Costa says, I have agreed to enter into a loan agreement with Cyprus Capital to advance a further $1 million to allow Cyprus Capital to provide the financial support to the club up to the amount of $1 million if and when the club is returned to the control of duly elected directors. So there's an allegation here that they're not appropriately elected.
Yeah. So did the court decide that?
Decide that the directors were unduly that they were not duly elected? No. So they're in this position. The directors, for whatever reason, and the court has considered that there might be an alternative purpose. They haven't completely expressed that there was no possibility that the allegation was that the election of voluntary administrators prevented the directors from being for facing re-election. They haven't addressed that fully. They haven't ruled that this is factually the case.
Okay.
They've allowed room for that potentially to be the case, in my view, although my reading of it suggests that. However, that's not the question. And they've pulled back attention to the key question, which is whether or not the entity is likely to be trading insolvent in February. And regardless of the multiple factors trying to persuade them, Dr. Costa was trying to persuade them that the company could remain solvent.
Yeah.
Because of the condition of the club membership approving any relevant deal that goes forward, they say no.
But the club's chair that appointed the administrators, among some other directors, they're still contending that they think the club is insolvent and the administration should remain on foot in this.
Likely to become insolvent.
Yeah.
They view it as being hopeless without the they seem to. I don't recall a particular affirmative statement as to the fact expressed in this judgment, but it's pretty clear in this reading that they formed that view. They don't see a way out of the mess because they can't obtain further finance and they can't dispose of the property. So
and they don't want to take Dr. Costa's loan because they don't want to step down.
Well, perhaps they could.
Is there a DOCA proposal? What's the end game with the administration?
Well, I don't think that's the end game. The administrators are seeking confirmation from the court that they are appropriately appointed.
Sure.
So it's still, they're figuring it out. Everyone's figuring it out. But I think that the refusal of the loan is actually less to do with whether or not the directors have to step down and more to do with accepting this sort of refinancing actually is something that also the members need to approve.
Yeah. I see. Because
they're-
if they
they're
need to
tied.
sell the property,
Mm.
presumably then they'd also need member approval if they were going to go and mortgage the property to the hilt, let's say,
Mm-hmm.
because it's sort of the same thing in a way.
Precisely.
Gotcha.
Although, again, I don't know if it's to the hilt because they're saying they have $54 million worth
Well,
of property and there's only $1 million loan to keep working capital.
I mean, it's still conveyance of sorts. Because remember, the old school way of looking at mortgages was effectively selling the property to the bank, and then you buy it. You're buying it back. I think it was a very old school way of looking at mortgages.
Giving the deed to the bank, and they hold the deed, in all title.
Well, that's part of it, but I don't know. I'm trying to remember like legal history at school, sort of thing.
Well, that's still a thing, isn't it? You still provide the deed to the other side. The bank carries the deed of the mortgage.
No, there's no deeds anymore. Deeds are gone.
There's a digital deed.
No,
completely.
Yeah.
Whoops.
Yeah, it's changed. You used to have duplicate titles, they were called. Yeah. So there was a paper title, and then there was a digital title.
Yeah, that's right.
And then they got rid of the paper titles. There was only digital titles, and now they're just completely not a thing.
What do you mean not a thing?
So, for example, in New South Wales, until it was a few years ago, I think they did it. When there was a mortgage held by a bank, right? And there was a thing called a right to deal. I think that's what it was called in New South Wales. They called it something different in Victoria, but you couldn't deal with the property unless the bank allowed that right to deal. It's a trigger in the electronic system. So you needed the bank's consent to put on another mortgage. They got rid of that. So there's a huge difference between New South Wales and other states. For example, in Queensland, you could just go and put another mortgage on without anyone questioning it, really. It had to be done through PEXA, so it had to be a lawyer or conveyancer, and they're going to get in trouble if they do the wrong thing. In Victoria, you did need consent, so there was that sort of right to deal thing. I think they called it something different, but under the legislation, a mortgagee could not refuse consent. It was you just can't refuse consent, but it still required that step to be taken. In New South Wales, the bank could refuse consent for a subsequent mortgage, but that's gone now because there's no longer a right you no longer need that trigger in electronic conveyancing system.
Did they need a basis to refuse it?
In New South Wales?
Wales. Really?
No.
So
not to my knowledge.
That first mortgage has the capacity to completely control. You can't refinance.
Well, you could refinance with equitable mortgages.
But you can't, yeah. I seem to remember.
Not refinance, but you can you could still do equitable mortgages without the bank's consent. But it's sort of dependent.
Mortgage without the first mortgage's consent.
Yeah.
I seem to remember
get a registered mortgage.
I seem to remember the certificate of titles, the original copy of the certificate of titles being couriered in those sort of transactions being a big thing.
Yeah.
So that's interesting. Not a deed. Yeah.
Yeah.
That's what I'm thinking of.
Yeah, it was the certificate of title. The old school deeds were I came across a few.
Really?
Yeah. I came across a few.
One. Old title. I hear there's a lot of farmland with old title, or there used to be. I'm not sure. I'm not up to date in this field. Yeah,
I don't know if they just completely got rid of it by now.
There was a definite push to do that.
Well, you couldn't deal with property for decades. You couldn't deal with property that was old system title without actually converting it. So you couldn't sell it. You had to convert it in order to sell it. Yeah. They may have just gone and converted it all by now. I don't know.
Maybe. You should look it up.
I've seen some. Yeah, I've seen some really old stuff. through like really old searches, and I had a Queensland property where a title deed was sitting in a bank's like storage facility in Adelaide, and had to get that cleared. Yeah, that was interesting.
Sounds
And
interesting.
I had the old, like the from memory, I think it had the like stuff stamped on it. I also saw another property where it was just like going back through historical searches, and I got to a document that had like mortgages were just stamped on the title deed. Wow. Yeah, it's pretty crazy.
I heard like they contain records of all of the former owners as well. So you have like.
Well, that was the old system. I don't think.
Yeah.
I think the thing I was looking at was still Torrens, but just like the really early Torrens. But yeah, yeah. So they stamp the mortgage and then they like scratch it out, and the certificates or the title deed still stays the same,
right?
And it has some really old language at the very start of it. Anyway,
it's fascinating.
Anyway. I digress.
Yeah. All right. So, jump to the conclusion.
Yeah.
So, one of the things that's discussed is the allegations are advanced somewhat on the basis that essentially the effect of this is to take the future of the club out of the hands of the members. And that's addressed as well. Justice Black makes specific reference to this in particular. So the first of these matters is, to the extent that it occurred, a necessary consequence of the structure of Part 5.3a, so voluntary administration of the Act, and does not establish generally, or in this case, an improper purpose in invoking the part where a company is insolvent or, as here, is likely to become insolvent at a future time. So even though that's the effect itself is not evidence of the accusation that's being made, that that's the purpose for which it was embarked. In that situation, there's no basis to contend the legislative choice to place a decision-making in the hands of creditors cannot be properly implemented. You know what? I'm not even sure what that sentence means.
In that situation? That one?
Yeah.
There's no basis to contend that the choice to place decision-making in the hands of creditors cannot properly be implemented. Well, I think he's just saying that if I can sort of summarize, that he's not convinced the VA mechanism is being used for an improper purpose.
All right.
In any case, the future of the club, its property was here not taken out of the hands of members, where the administrators make clear that they do not expect to sell the property during the administration. Any sale of the club's property would likely require the approval of members under Section 41E of the Registered Clubs Act. So it's the requirements of the Registered Clubs Act.
Oh, really? I thought it was a constitution. I mean, skimmed over that important part.
I mean, I have not looked at the Registered Clubs Act, so maybe.
Well, that suggests that every registered club is bound by this particular provision, which is pretty hefty.
Which, would be a good reason to try and use the administration to circumvent it.
I think
it sounds like a bit of a nightmare.
The key thing is that Justice Black discusses this. He says that this is not evidence of this fact. But the reality is it's possible that a discussion occurred where that was discussed. But regardless of that fact, the threshold is actually met, because there's no way of getting out of this hurdle, not that I can see, without the vote. And the vote is a condition. And as Justice Black says, it would be speculation.
Yeah.
And speculation isn't a good basis to be able to judge these sort of things. So it meets the threshold.
Yeah, because bear in mind, you can appoint administrators. It's not the end of it. The administrators can look at it and say, "Oh no, it's fine. Just do this, this, and this, and you'll be sweet." That's the recommendation. Creditors go, "Okay, give the company back to the directors."
Yeah,
it hardly ever happens, but Good.
but it is possible. There's no evidence that supports a finding that the pleaded conduct or appointment of administrators, rather than being motivated by the club's debts falling due in early 2025 and its inability to sell the property because of that requirement in the Registered Clubs Act, where the previous attempt to obtain member approval for that sale had been restrained, was motivated by any purpose of preventing the director's replacement. There is no reason to doubt Mr. Kelly's evidence that several of the directors do not wish to remain in office. And the appointment of administrators suspended the directors' powers rather than preventing their replacement by a new board. I could not reach that finding. There is also no evidence to support a finding that the directors appointed the administrators to protect the true and proper accounts being prepared. There's no evidence of that, and no reason to think that the directors had any wish to avoid the preparation of proper accounts. In any case, the appointment of an administrator would be more than likely to reveal than conceal the club's financial position as a result of the administrator's investigations.
Yeah.
So essentially, they've said, nope, you're not going to win this one. There's not sufficient evidence to demonstrate that this was.
So Dr. Costa is a conspiracy theorist after all?
So it would seem.
Maybe.
Yeah, conspiracy theorist doesn't necessarily mean wrong, but there's no evidence. There's no evidence. And if the directors are backing out and Mr. Kelly's given evidence that the directors don't want to remain directors, as is understandable in the middle of an insolvent trading business, then it's past this, right?
All right. Well, my spidey senses were right then in the first place.
Very accurate. I think that was a really interesting decision and a good reminder that the outcome is not evidence of an intention. And the threshold is a legal threshold. It's a strict legal threshold. And whether or not it's satisfied, you got to look at the actual threshold rather than looking at what motivations of directors might be.
The threshold is the directors just have to have the honest belief that the company is likely, it may become insolvent.
Yeah. Under Section 436A of the Corporations Act, if the board
held the specified belief that the companies were insolvent or were likely to become insolvent in the future.
Yeah, just
specified belief. I'd say reasonable. Well, that's what they're saying there. Specified belief.
So traditionally,
if the director's opinion as to insolvency is not held, or is not held genuinely or in good faith, a resolution passed by the directors to appoint the administrator is invalid.
So that's it. It has to be.
They don't believe it, or they're not believing it genuinely or in good faith.
Yeah, that's the threshold. All right. So thanks for joining us today. We'll see you next time.
Thanks, Bernie.
That's a pretty interesting case and not an unimpactful one.
Unimpactful.
Impactful upon me. I've learned like 6 different things today.
What kind of word is unimpactful? Is it like synergy?
It's synergistic.
Synergistic.